And I begin with the observation that there are few principles in our society more important than equal justice under law. The idea that no man or woman is above the law is firmly embedded in our nation's founding documents and underlies the entirety of the criminal justice system. When clemency is granted outside the normal pardon system, and particularly when it's issued to members of the president's own administration, that fundamental concept is called into question. I respect the president's authority under the Constitution to grant clemency. At the same time, I would hope that the White House would acknowledge our role as co-equal branch of government, with not only the right but the duty to conduct oversight. Today, as part of our oversight responsibility, I hope we can obtain answers to several important questions surrounding the President's recent decision to commute the prison sentence of Mr. Libby. Was the grant of clemency here consistent with other pardons and commutations by this President? Were the prosecutor, the pardon attorney, or other relevant officials in the Department of Justice consulted before the commutation was issued? Was the process to consider the commutation fair, thorough, and available to similarly situated individuals? Was the net result of the commutation consistent with the nation's sentencing guidelines? Looking at his initial public statement, the President evidently believed that the 30-month prison sentence issued by Judge Walton was too harsh, but felt some punishment was appropriate, in this case a fine and probation. Is there any construction by which this ultimate sentence is consistent with sentencing guidelines? If not, do we need to reconsider the guidelines so that whatever factor the President identified can be taken into account in future sentencing decisions for others? What impact will the President's decision have on Congress's ability to learn how Ms. Plain came to be outed from the CIA in 2003? Was her outing the inadvertent result of a slip of the tongue by a government bureaucrat? Or was it part of a larger conspiracy to besmirch Ms. Plain and her husband, Ambassador Wilson, who had written an op-ed criticizing the administration? Does the fact that Mr. Libby has received a commuted sentence rather than a pardon inhibit Congress's ability to learn the truth? Some have sought to divert our efforts to ascertain the truth in this matter by focusing on unrelated issues, or by muddying the facts of the Libby investigation. For example, it's been asserted that criminal charges should never have been brought against Mr. Libby, or that there was never an underlying crime. But of course, this belies the fact that Mr. Fitzgerald's investigation found that several individuals, including Mr. Libby, leaked classified information not just to Mr. Novak, but to the New York Times, Time Magazine, and other publications. Some have tried to turn our attention to the events of some 7 years ago when President Clinton pardoned Mark Rich. I did not support that action, but whatever its demerits were, it was investigated in 4 separate hearings in the Senate and the House, and it did not involve someone who worked in the White House and who could potentially implicate others there, as may be or appears to be the case in this instance. And I close by noting that if we're truly to get to the bottom of the controversies surrounding the President's commutation of Mr. Libby's prison sentence, we would need to hear from two additional parties. The first is Special Counsel Patrick Fitzgerald. He declined our invitation to participate today, but I hope that at some point he will offer us his perspective and that he does so when it's still timely and relevant. The second party, of course, is the White House.